So for those of you who are on the line, I just want to welcome you to our webinar on estate stewards. I first want to acknowledge a couple of key points that are intrinsic to our estate stewards. First of all, people matter. And with this philosophy, we provide truly customized services through one point of contact for all estate needs. And this results in true peace of mind. And the second is our mission statement for estate stewards. Estate stewards serves as a single point of contact, bringing all family members and needed professionals together for a common goal, to care for your financial affairs now on an integrated basis, and the estate of the future, and the one point of contact. So this provides real peace of mind because people matter. And it is that being said, we are fiduciaries at Portfolio Stewards, and we felt a call to find a person that embodies our mission statement. And we believe that Nicholas Myers, due to his extensive background, both nationally and internationally, was the ideal individual to head up this area. He's bilingual both in French and English, and he is bilingual both in the trusts and as a trust and estate practitioner with a comprehensive portfolio in all aspects of trusts, businesses, and family office. He's passionate about the work he does for clients, and his experience includes both international estate planning, meeting the overall needs of high net worth clients and beneficiaries by providing strategies and solutions for the setup of various structures for both legal, investment, and real estate transactions. He's a business development strategist who creates strong and dedicated client relationships and partnerships that are built on trust. We as a firm have experienced his professionalism, his interpersonal and leadership skills, and his attention to detail. This absolutely is a reflection of his Swiss background. And as Nicholas works through the slides, I believe that you will clearly see that his desire to assist each individual client and how he can benefit your respective firm will become evident. With that, take it away, Nicholas.
Thank you very much, Peggy, for the introduction. Good afternoon to all of you. I hope you're all doing well. I'm going to try to make this presentation as short as possible and to describe it in a nutshell what we can provide and how we can help your clients and build a mutually fruitful relationship. So the agenda will be pretty short. What services does Estate Stewards offer? What is the benefits of our services to your clients? And how we can recognize a client in need of assistance. And we will wrap up with the conclusion and the Q&A. So these are basically the services that we'll provide. First, the assistance in getting the estate document in place, and then either acting as executor or agent of the executor, as attorney or agent to the attorney, and as trustee or agent to the trustee. And finally, we will ensure periodic review of the estate planning. First, perhaps the most important first stage is the assistance in getting the documents in place. Well, we all know what is the issue at stake currently. More than 50% of Kenyan residents don't have a will, which is really a major issue. So the first thing is to ensure that do the clients have already documents in place? Because if they haven't, well, we really have to start the whole reflection process. And this is not an easy one. Let's put it this way, because it's a difficult conversation, and the fact that there are only 50% of the Kenyan residents who have a will is just an indication that a lot of people are procrastinating. And I'm pretty much sure that we will all share the same opinion. Why they're procrastinating? Because basically the estate documents, whether the will or the power of attorney, are nothing other than dealing with your own demise or your own future incapacity, which is not very, let's put it this way, glamorous. But we have to assist the client in this process. We have to literally take the hand of the client throughout this process. So if they don't have any if they don't have any documents, that basically is starting from scratch the whole reflection process. If they have documents, the key thing is to have up-to-date documents. And I've seen quite often documents which were more than 10 years old. Unfortunately, basically, they're always outdated, because in 10 years, so many things can happen. Your children who were very small 10 years ago, now basically they go to university, or they have become fully independent. So it no longer reflects the current reality. And that is key. Also, with regard to the appointment of the executor, well, if you appoint an in-law, and then unfortunately there's a marriage breakup, well, it might be a good thing just to it might be a good thing just to amend the will in that regard. So yes, what shall we do? We shall have the discussion with the client, help them in this reflection process, check whether we can make it the more efficient possible, how we can assist them in order to make it the most efficient way possible. Basically, is taking them to the stage where they will go to the lawyer. But we will have done with them, we have taken the hand throughout this process, and we'll have supporting them in this process. Because one of the key things in that case, in that regard, is that it's very emotional, it's very difficult, and quite often parents don't want to discuss that with their children. I can understand that it's not an easy discussion, but we are here also to support them and to go through this complex emotional process. So this is really the first part where we can act and where we can help. Second one, well, what can we do? We can act as the executor also, or we can act as the agent. So what does it mean to act like the executor? Basically, in all those cases where clients will require some help, we will be dealing with the full settlement of the estate, and we will all attend to all the required tasks. And we will obviously work closely with the advisor of the deceased. Naturally, you as accountant, this is very important because you have also a very good understanding of your clients. I think this is a fantastic tool and a fantastic service, because very often the clients tend to slightly overlook what it will mean in terms of burden, both emotional and in terms of workload. For example, if one of the children is appointed as the executor, well, this child is grieving the loss of one or perhaps the second parent, but has to act immediately as the executor. Nothing obvious at all. And there are obviously a lot of emotional consequences when one of the parents or the second parent passes away. So what shall we do? Basically, we will do everything from A to Z. And I've just listed some of the tasks that we will be attending to. Well, the first thing is, well, safeguarding the deceased assets, establishing the inventory, preparing and filing the probate application, the state information return. I would like just to remind you that actually we have to file an estate information return, which basically has to set out very precisely all the items which were subject to the probate application with a valuation, which might not always be completely obvious. For example, let's assume that you had watches. Well, what is the value of these watches? So you have to have them appraised. All that seems to be relatively straightforward, but it's time consuming. Obviously, and with your close assistance, ensure that all the necessary tax matters are attended to. And I would say last but not least, well, we will ensure regular communication with the beneficiaries and peaceful family relationships and managing beneficiaries' expectation. And I think this is one of the biggest upsides of this service. We know that as soon as parents pass away, it has a tremendous impact on the family dynamics. And very often people might be a bit surprised to see some of the reactions. I've heard quite often during my career, parents saying, "Oh, my kids get along so well." Oh, fine. The thing is, sometimes once might be a bit blunt, and please, my apologies for that. But sometimes once the money is on the table, it might trigger some unexpected and unpleasant consequences. Just going to tell you a story. It was a lady who had considered to appoint her 2 children as her co-executors. And we asked her, well, do they get along? Oh, no, it's more than 10 years they haven't spoken to each other. That might make it a bit complicated. And these situations happen far more than we could believe. So that is when we are acting as executor, which means that we will make all the decisions. But there's also a very different and interesting setup is when we act as agent. Basically, in terms of the workload, we will be doing exactly the same work. But the only difference is that the executor, usually family members, keep the decision-making power. And in that case, basically, we do all the legwork. And it's usually quite appreciated by families because we take on the workload and I'd say to some extent the emotional burden, but a family member keeps the decision-making power. And I think this is a very interesting and actually very good setup also for families, because they will feel comfortable that where we will ensure the proper assistance to the executor who is very often overwhelmed by what is happening. So this is really absolutely a great service, because basically we take all the burden, whether the work burden, the workload, or the emotional burden to a large extent. And we will help the executor to manage the relationships with the beneficiaries, who are often family members, because the thing is, very often, again, the family relationships are never that easy and that straightforward. So by stepping in as a third party, neutral third party, we ensure a much more peaceful settlement of the estate. And I've seen that in several cases. Well, sometimes that means that we will in effect act as an emotional buffer, but this is very, very powerful. A very quick one, how we are appointed. So if we are to be appointed, we have to be named in the will, and then we will ensure that certain wording is included and also the compensation agreement. I will not go into the detail after the death because this is really more complex. We can also be appointed as agent in a similar way than when you acted as executor, but we can also be appointed after the death. So the executor can very well say, well, I would like you to be my agent because I need your help. So that can happen at any time. It's much, in that regard, it's much simpler than the appointment at the executor. And this is something which should really be kept in the back of our minds, because very often what I've seen is that a family member who has been appointed as the executor has accepted that because he/she thought it was his or her duty, but had not realized at all what it meant in terms of workload and an emotional burden. So yes, we're here to help. We're here to take this burden off the shoulders of the named executor. We can act also as agent. We can also act as attorney for property. And an agent to the attorney for property, basically, it's very similar to the process when we acting as executor. Again, when we appointed as agent, we will do all the work, but the decision-making power remains with the named attorney. So this can be also very useful. For example, if you have perhaps an attorney who doesn't have a lot of time, or is a bit lives a bit not abroad, but perhaps even in another province, that can be really very helpful. Again, what will be the tasks that we'll be attending to? Ensuring the safeguarding the client's assets. Let's put it this way. For example, if the the person who has granted the power of attorney is now living in retirement or is in hospital, he cannot attend to his or her home, but that's the thing we will do, just ensure that the home is safely protected and properly insured. That's one thing. We will show that also we ensure the inventory of all the client's assets. And again, because that I've seen, once people are in hospital, usually the tax matters might not be their top priority. So just to ensure that this is properly attended to is a key thing. So again, we will be appointed basically in the same way than when you appoint as executors, which means that if we have the fiduciary role, i.e. acting as the attorney, we have to be named in the power of attorney. If we're acting as agent, then the attorney can very well appoint us at the relevant time. So basically, we can step in at any time. Finally, we can also act as trustee or agent to the trustee. So we can act as trustee of a testamentary trust or an inter vivos trust, Hansen Trust, for example. We can act as the agent to the trustee of such trusts. Again, it's always the same difference. When we take on the fiduciary role, we make all the decisions. When we're acting as agent, we are supporting the named trustee. That means, amongst others, what shall we do? Run the trust properly, according to the term of the trust with the tax requirements. And I'm saying that because from my understanding experience, a lot of people will be running trusts without really understanding what it means to run a trust. And it's anything but obvious, especially if we are dealing with a discretionary trust, because it requires really to run it in a very precise way. The fact that there is a full discretionary power means that you have a lot of power, and you have to document that, and it does require a lot of work and proper consideration. So yes, I think that there's no doubt that we can help a lot the appointed trustee to run the trust properly. So that is absolutely key. I'm not going to spend too much time in terms of how we are appointed, because basically it's the same that when we're acting as executor or agent to the executor. I think also now, one thing which is also very key, okay, let's assume the clients have, okay, they have put in place the documents. They might have appointed us as executor or agent to the executor. Now, 3 years, 5 years down the road, what is happening? Actually, well, unfortunately, the clients, there has been a marriage breakup, or now they have grandchildren, or well, there can be a lot of things happening within this 3 to 5 years period. And that is key, just to ensure, I would say, the maintenance, so to speak, of these estate documents, because too often people think, well, I have done my will, I have a will properly signed, they're in my drawer, I don't need to touch them for the next 20 years. That is not true. A will is basically a live document. So if there are no major events, we would strongly recommend that every 3 to 5 years, at the very least, we have a look at it. We ensure that it still reflects the current reality. If it's the case, fine. But quite often after 5 years, there has been quite a number of changes. A lot of things happen within a 5 years period. That, again, we will help the clients to go through this process again. And again, we're going to help perhaps mainly from, I would say, a personal standpoint, because it is always difficult. It's always difficult going through your will. Well, actually, I'm talking about my future demise. It's not very nice, not very attractive, to say the least, but we're here to help during this process and to support them and to, quote unquote, take the hand of the clients. So what are the benefits of services to clients? First, intergenerational peace of mind. I think I'll never stress enough the fact that families are always relatively complex. And when there's a combination man and family, it's never a good one. It's never a good one. The fact that the third party, professional, and totally neutral from an emotional standpoint steps in is such a huge upside that it does help so much the families to keep decent relationships, because very often the family litigation during an estate settlement is due to the fact that the parents did not have a clear conversation with their children. Everything was kept hidden, or let's not talk about money. But the thing is, at some stage, you will need to have this discussion. So the sooner the better. If the clients can have that discussion while they're alive, calmly during a family meeting, that's 10 times better. And as one lawyer told me one thing which was so true: a proper estate planning is 10 times less costly than an estate litigation, because once you're embroiled in an estate litigation, you know when it starts, you don't know when it's going to end, and there are no winners. There are no winners. The family is torn apart. The family relationships are destroyed. Well, obviously, it generates a lot of fee for the lawyers, but there are no winners at all. So we are here to help the clients avoiding that. I would say I will not dare saying at any cost, but not very far from that. So we also ensure from a technical standpoint that the fiduciary duty is properly attended to. For example, when there's a child who is appointed as the attorney for property, sometimes this has been seen that the child's thinking, well, anyway, I'm dealing with my future inheritance, so I can basically spend without any restrictions the money of my parents. No, that is not true. You have to step in and act in of the grantor, and that way we're here to help to manage that, because we are acting as fiduciaries. And again, I would like to emphasize on that: not neutralize all the emotions. There are so many emotions involved in a family, and we are here to help them in that regard. So, in a nutshell, what we want to be, being the indispensable professional, ensuring that all matters, the technical matters, are properly addressed. And I always like to say, allowing the family to keep sharing the Christmas dinner. And it's really, at the end of the day, this is the real invaluable service. So I would like to wrap up briefly with how you can recognize the client in need of assistance. While there are several cases which might need some additional support, the blended families are never obvious. Client with no kids, and no one being able to act as attorney executors. The business owners, when there's a corporation involved, this becomes far more complex. When the clients have family members or assets abroad, the cross-border issues, most of the non-professionals have very little knowledge about the complexities. And for example, there are very few, for example, double tax treaties in terms of succession in estate and inheritance. So this is really something which is really complex and which has to be properly attended to whilst putting in place the estate documents. Well, the client citizen of another country, typically the US, and when you have complex assets, you can have, for example, real estate, when you have a portfolio of real estate assets, or when, for example, if you have a portfolio IP rights, this is really becoming more complex. So I would like to in terms of my closing remarks, I just wanted to mention we are currently recording several podcasts on the estate planning matters. You have the links on the slide. So just we are addressing some of the estate planning matters in a friendly and informal way, and we would be very pleased if you could listen to this podcast. We're not just sharing, exchanging about estate planning issues and considerations. So Q&A. So do you have any question?
If anybody does have any questions that they would like Nicholas to address, you can ask them via the Q&A panel at the bottom of your screen. Just hover over the bottom and you should see that there. Just looking at it now, we do have one question that's come in, and that's, how often should your will be reviewed, or should a client be reviewing their wills?
This is a very good question, but I would say that if as soon as there's a major event, typically birth of grandchildren, marriage breakup, death, or anything, or for example, liquidity event, what you've just sold your business, that should be the opportunity to review the will. If there are no major events, have a look at the estate documents at least 3 to 5 years, because these tend to become updated quite quickly. And to be honest, any document which is more than 10 years old will be more or less, as a matter of principle, outdated. So anything which is more than 10 years old, you can reasonably think that there will be at least a need for some kind of amendments.
Excellent. Okay, we have one other question that's come in. Can I refer a client for estate services if they're not a current financial planning or investment client of Wealth Stewards?
Absolutely. We are very, very happy to help any client who will need these services. Absolutely. We will have a preliminary chat. And I think one thing also which is important, that we will not be charging anything as long as we are not acting either as agent or executor. So we will have always a preliminary chat to understand better the situation of the client and to see how we can help. So yes, you can absolutely refer any client to us, and we will be very happy to assist the client as much as we can.
Great. There's just one other question here. What benefits would there be to my firm to offer clients estate services? I presume that they have wills, and I'm trying to understand if that if I spend the time to have these discussions, how I can bill or increase revenue for my firm. Based on that.
Thank you for that. Obviously, we will be working very closely with the accountants and ensuring that basically we are creating a fruitful relationship for both you and us, because we have the same common interest to help the clients. And obviously, but helping your clients in these difficult estate matters, that will be, I really believe, a win-win for everybody, because your clients will be happy to have all this burden off their shoulders and say, oh, that was a great referral, thank you so much. And this will be a perfect way for you, I believe, to keep and grow your client's base.
Excellent. On that note, then, if they have a client who needs estate planning, who should they be contacting? You directly, Nicholas, or?
Absolutely. So I have put my email address on the last slide. So feel free to drop me an email. I'll be very happy to schedule the preliminary meeting, and we'll take it from there, because every situation is different. And that's the beauty. That's why it's so fascinating, and I have such a passion for this matter, is that every family, every client is different. There's not one client who has a situation which is identical to another one. And our goal and our main goal is really to help families keeping together. And that is for us, if we help the client to achieve this objective, it's all good.
Perfect. Thank you very much, Nicholas, for those excellent answers. If there's no other questions, then I think this is a good point to end on. Thank you, everybody, for joining us today, and thank you, Nicholas, for sharing your expertise. We will be sending along a recording of this presentation, along with the information on the podcast that Estate Stewards is now producing, in an email tomorrow to all attendees. Thank you very much for joining us, and I hope you all have an excellent day.
Thank you very much. Have a very good day.